C-11, the Digital Charter Implementation Act 2020.
Moves that Bill C-11, an act to enact the Consumer Privacy Protection Act and the Personal Information and Data Protection Tribunal Act, and to make consequential and related amendments to the two other acts, be now read a second time and referred to the Standing Committee on Access to Information, Privacy and Ethics. Debate. The Honourable Minister of Innovation, Science and Industry.
Thank you very, very much, Mr. Speaker. It is with great pleasure that I rise today to discuss Bill C-11, the Digital Charter Implementation Act 2020. As members know, data and digital transformation is completely changing the way we access information, buy goods and services, connect with each other, and live in our communities and cities. This digital transformation has been accelerated by the pandemic, where we're seeing more Canadians moving their activities online. And Canadians are using more digital services and sharing more data online than ever before. And they want to know that their personal information will be safe and that they are protected. You know, recently, the Privacy Commissioner surveyed Canadians and found that the vast majority of Canadians, 92% of Canadians, are concerned about the protection of their privacy. So this is an important issue to many, many Canadians. That is one of the reasons why last year I launched the Digital Charter, a set of 10 principles that lay down the foundation that will allow us to build an innovative digital economy that is inclusive, people-centric, and built on trust. The
principles of the Digital Charter will allow Canadians to have greater control over their data while helping companies to innovate, to expand, and to create quality jobs for Canadians in the middle class across the country.
And I'd like to take this opportunity to remind members that the principles of the Digital Charter were very clear, and they focused on control and consent. Canadians will have control over what data they are sharing and who is using their personal data and for what purposes, and know that their privacy is protected. This is one of the key principles that we laid out in the Digital Charter.
Transparency, accountability, and interoperability. Canadians will easily be able to control access to their data and be able to communicate this data without an undue burden.
Digital for good. This is another principle that was laid out in the Digital Charter. The Government of Canada will ensure the ethical use of data to create value, promote openness, and improve the lives of people at home and around the world. How can we harness data to solve problems? Another key element was strong enforcement and real accountability. There will be clear, meaningful penalties for violations of the law and regulations that support these principles, so Canadians can rest assured that their privacy will be protected. Madam Speaker, as you will see, the principles of the Digital Charter are firmly embedded in the legislation before us today. And on top of this foundation sits 3 pillars: consumer control, responsible innovation, and a strong enforcement and oversight mechanism. So let me begin with outlining how Bill C-11 gives Canadians more control and greater transparency in how companies and in the manner in which companies handle their information. It does this by introducing important rules around consent, the right to delete information, data mobility, and algorithmic transparency. So with regards to consent, Bill C-11 enhances consumer control by requiring organizations to get meaningful consent from Canadians. This means that individuals will get specific information in plain, simple language, not the 30-page legal document that no one reads. This, in turn, will allow individuals to make meaningful choices about the use of their personal information. And to make consent more meaningful and move away from lengthy agreements that, as I said, no one reads, we're introducing a new exception to consent for the collection and the use of information for standard business activities that would be reasonably anticipated by individuals. Pour vous donner un exemple,
For your data, for example, when you buy something from a company and you give them your address, this company can disclose your information to the delivery company so that you can receive the product that you paid for.
that company will need to be transparent about how they use personal information so that consumers are made aware and that the Office of the Privacy Commissioner can review these practices. The second element I want to talk about is the right to delete information. C-11 allows Canadians to withdraw their consent and demand that the data be deleted. So when an individual no longer wants to do business with an organization, that organization must stop using their information. And they must delete it permanently if it is asked by the individual. This would, for example, allow a Canadian to demand that a social media site delete their profile. Very simple, but very powerful. The next area that this bill highlights is around data mobility. To improve their control further, individuals will also have the right to direct and transfer their data and their information from one organization and one entity to another organization or another entity in a very secure manner. Bill C-11 will do this by enabling regulations that establish frameworks for secure transfer and interoperability. And this approach would support innovation in areas like open banking, where a common technical approach could allow Canadians to take advantage of the consumer-directed financial marketplace in a more secure way. Another area this bill touches on, which was highlighted through extensive consultations, is around algorithmic transparency. In the area of consumer control, Bill C-11 improves transparency around the use of automated decision-making systems, such as algorithms and AI technologies that are becoming more pervasive in the digital economy. And under Bill C-11, organizations must be transparent that they are using automated systems to make significant decisions or predictions about someone. It also gives individuals the right to an explanation of a prediction or decision made by these systems. So how is the data collected? How is the data used? So, Madam Speaker, this is a brief summary of what you will find under the first pillar of this legislation, under more consumer control. The second pillar of Bill C-11 is enabling responsible innovation. L'économie numérique offers
The digital economy does offer sizable possibilities for Canadian companies. Digital activities represent 4.8% of our GDP nationally, and tech companies are the best equipped for R&D in the Canadian sector.
in data has climbed as high as $40 billion. And across the economy, Canadian companies' data is worth as much as all other intangible assets, such as software, research and development, and mineral exploration rights combined. So you can see the potential of data, not only today, but going forward. And globally, we're seeing unprecedented growth in technology, in the technology sector. Growth that is only going to pick up as artificial intelligence continues to grow and have a more meaningful impact in our lives. And according to some estimates, AI is going to contribute an additional $13.7 trillion to the global economy by 2030. En tant que gouvernement,
as a government, we also recognize the importance of giving companies clear regulations that allow them to conduct their activities while protecting the privacy of Canadians. It is the pillar of our economic growth and innovation. When Canadians trust that their data is safe and that their privacy is respected, this creates space for innovation that benefits everyone.
our government believes that greater trust and certainty in the digital marketplace will empower small businesses and entrepreneurs to create new jobs, create new opportunities, expand their operations, and better access the global marketplace. I think it's also important to note, Madam Speaker, that the new legislation will help small businesses prosper as well by ensuring the rules around data and privacy are fair, clear, and enforced, and flexible enough to meet the needs of smaller organizations. So one area that does that is the codes of practice and certification systems. To enable responsible innovation, Bill C-11 will create a framework to recognize the use of codes of practice and certification systems. This will help organizations both comply with the law and demonstrate their compliance, which in turn will support innovation and provide an important balance to a strengthened enforcement regime. Organizations will be able to apply to the Privacy Commissioner to approve a code of practice outlining how the Act's general requirements apply in a particular sector or a particular activity. This would give businesses some certainty that if they're following the code, they are in compliance. I also want to highlight de-identified information. Bill C-11 will also clarify how organizations are to handle de-identified personal information. And this enables an important mechanism for both privacy protection and innovative uses of data, which is going to benefit many, many small businesses. Lastly, data for good. I think in this area it's important to note that under the second pillar of enabling responsible innovation, C-11 recognizes an exception to consent for socially beneficial purposes in order to clearly allow organizations to support innovative data initiatives, such as data trusts, pursued by a range of public institutions, including hospitals, universities, and libraries. There is so much potential with data trusts because it can enable us to really unlock some of the opportunities that exist to solve some problems across our society. The next element I want to talk about is strong enforcement. But perhaps more importantly, the proposal will significantly strengthen the enforcement and oversight regime. And this is critical.
Thanks to this proposal, we will have certain sanctions amongst the toughest in the world to respect rights.
The Privacy Commissioner has little ability to enforce his recommendations to organizations that are non-compliant, other than seeking a hearing by the federal court. But under C-11, this will change. The legislation introduces a strengthened privacy regime that will be overseen by a more powerful Privacy Commissioner with appropriate checks and balance in place. The Office of the Privacy Commissioner will have broad order-making power, including the power to force an organization to stop collecting or using information and delete it. So if the Office of the Privacy Commissioner finds out that this data was collected in a manner without the appropriate consent, he has the ability to do this. And the Privacy Commissioner will make sure that there's going to be strong and meaningful consequences for organizations that do not comply with the law. The Privacy Commissioner will have the power to recommend administrative monetary penalties of up to $10 million or 3% of global revenues, whichever is higher. And the range of serious criminal offenses will also be expanded. And with a new maximum fine of up to $25 million or 5% of global revenues, whichever is higher. And the legislation introduces the new Personal Information and Data Protection Tribunal, which can review appeals of the Commissioner's orders and levy penalties. Ce nouveau tribunal.
This new administrative tribunal will contribute to ensuring procedural fairness in the operation of the new powers of the Commissioner. It will enable individuals and organizations to have better access to justice through a less cumbersome appeal process.
We'll recognize that early compliance with the Act remains critical, and that's the key part. Early compliance will remain critical for the protection of Canadian privacy. We need to build on the Commissioner's existing abilities to secure early resolution through compliance agreements. So we want to make sure that Canadian companies actually comply with the legislation. In this new regime, we'll see stronger collaboration between the Privacy Commissioner, stakeholders, and implicated institutions, including federal organizations. And when the Commissioner is developing that guidance, it's important to have that level of collaboration. And this will ensure there is a strong alignment between the law and how it is explained and enforced, and help avoid confusion for those trying to follow it. So this is, again, going to provide further clarity. To summarize, the third pillar of C-11, strong enforcement and oversight, introduces an escalating model that provides incentives for organizations to comply early. Again, the focus is on compliance. Strong penalties will exist if they do not follow through, and a new tribunal to ensure that the process will be fair, transparent, and accessible for businesses of all sizes. The three pillars of C-11 work together to provide what Canadians need to engage in the digital economy: strong and enforceable protections for personal information, along with clear rules for businesses to follow as they innovate and deliver new products and services. It's also important to note, Madam Speaker, that this legislation will help protect the privacy of Canadians while strengthening the ability of Canadian businesses to compete globally. So this positions Canada to succeed internationally. Madam Speaker, when PIPEDA was introduced in 2000, it was considered a global leader among data protection laws. And in 2002, the European Commission found that PIPEDA provided adequate protection relative to EU law. And the finding of adequacy gave us an international edge by allowing us for the ability to have free flow of data between Canadian and EU companies. And more recently, in 2018, the EU brought in its GDPR, the General Data Protection Regulations, into force. And since then, the EU has been reviewing Canada's advocacy against the GDPR. And they have made it clear that we must reform our privacy regimes in order to maintain our advantage when it comes to the status. So, Madam Speaker, I believe this legislation will achieve GDPR adequacy while maintaining the Made in Canada approach. Lastly, I want to conclude by stakeholder reactions. This approach reflects years of public study, consultations, and collaboration. It builds upon the fundamental work of the House of Commons Standing Committee on Access to Information, Privacy and Ethics, as well as important deliberations in the other place. And I can tell you right now, this legislation has gained support from a wide range of stakeholders. Goldie Hyder, the President and CEO of the Business Council of Canada, spoke positively about this. Michael Geist, who's well recognized in this area of expertise, said this is Canada's biggest privacy overhaul in decades. Open Media calls Bill C-11 a big win for privacy in Canada. So nous savons que les Canadiens.
We know that Canadians will continue to use digital services. There's no going back.
Last remark. As the COVID-19 pandemic continues to increase our reliance on the digital economy, Bill C-11 will help Canadians embrace this new world, knowing that their personal information is protected and safe. Thank you.
Thank you. Questions and comments? The honourable member for Sturgeon River Parkland.
Thank you, Madam Speaker. I thank the Minister for his speech on this important legislation. I saw from the stakeholders that big business certainly likes this bill, but I want to talk about small business. Small businesses that, like insurance companies, for example. He's talked about data portability and open banking. Currently in Canada, the insurance arms of banking companies are not allowed to share that information with their mother company, the bank, and this creates a competitive playing field for small and medium-sized insurance companies. So I'm wondering if he can address the concerns of small and medium-sized insurance companies that their business is going to be severely disadvantaged by this legislation, and what efforts are they going to make to help those companies? Thank you.
The Honourable Minister.
I'd like to thank my honourable colleague for his very important question. As I highlighted in my remarks, this legislation is good for small businesses. It provides them the ability to work with the Office of the Privacy Commissioner to create codes of conduct to enable them to be compliant with the Act. The tribunal process is also less expensive and onerous for small businesses, particularly when you compare it to the lengthy processes that they may have had to pursue in the past in the courts. But more importantly, I think this legislation gives control to Canadians, particularly in the area of portability, as the member opposite highlighted, by enabling small businesses to be able to take advantage of the fact that Canadians can now move their personal data from one organization to another. That creates more competition and more choice, which will have a positive impact on small businesses.
Questions and comments? The honourable member for Jonquière. Not Jonquière? Oh, my. Saint-Hyacinthe-Bagotte, is that right? Yes, that's right. Thank you, Madam Speaker. Nice try. Nice try, Madam Speaker. So my question for the Honourable Minister is, if Quebec is reflecting on, if our personal data belongs to us constitutionally, if it's under provincial jurisdiction, under property and civil rights, given that Quebec is modernizing its own legislation, how do you see these two pieces of legislation or two bodies of legislation fitting together? I'd like to remind the member that the questions have to go through the chair. The Honourable Minister. Thank you, Madam Speaker. I'd like to thank my colleague for his question. He's right. Absolutely. Privacy is essential to all Canadians.
Use this legislation to make sure that it is also adequate with GDPR, as I mentioned in my remarks, and will also respect provincial legislation. This demonstrates national leadership in an area where it's important to have clear rules to protect Canadians, to protect their privacy and their data, but this law will respect provincial jurisdiction.
Questions and comments? The Honourable Member for Timmins James Bay.
Thank you, Madam Speaker, and I want to thank my honourable colleague for introducing this bill and thank him for recognizing the work of the All-Standing Committee on Privacy and Ethics that brought forward a number of these recommendations. It is essential we move on this legislation. I have some concerns when I look at the legislation, and one of the key concerns I have is that the government has opted to ignore the need to bring political parties and third-party political operators under some form of privacy regime. I'm sorry, but a pinky swear from a party staffer that they have a privacy code doesn't cut it. Not after what we've seen with the Cambridge Analytica scandal, the big data wars that are going on with political campaigns in the United States. We need to have political parties under some kind of regime. Is the government willing to put this under regime if we bring forward amendments?
The Honourable Minister.
Madam Speaker, I'd like to thank my honourable colleague for his active role in this area. I know that the Ethics Committee has done tremendous work in terms of providing recommendations which have been incorporated in this legislation that I've just spoken about. I think with regards to political parties, it's important to note, as the members indicated, that this legislation is focused on commercial activities. And so we're looking at not non-commercial activities, but commercial activities, and to strengthen the privacy in this area, and to make sure that Canadians have more control, not less control, that there's greater transparency and greater accountability and meaningful fines, which will make sure that organizations comply with the law. That's the objective. But again, it's focused on commercial activities, not non-commercial activities.
And comments? The Honourable Parliamentary Secretary to the Minister of Indigenous Services.
Thank you, Madam Speaker. And first of all, I want to congratulate my friend on being featured in this year's LinkedIn Top Voices profile. So congratulations on that. And I'd like to just ask him about data mobility and how this bill will assist Canadians and Canadian businesses in obtaining data mobility. Is an issue that we've heard a great deal about over the years.
The Honourable Minister.
I'd like to thank my honourable colleague for his friendship and support. I sought his counsel on numerous occasions to get his advice on issues that he heard from his constituents, and he made it very clear that Canadians should have more control over their data, that Canadians should have greater privacy online, because as he reminded me, particularly in this pandemic, more Canadians are learning online, working online, accessing information online. And so one area where we targeted and honed in on providing greater control for Canadians is around data portability. And this will enable, as the member clearly highlighted, the ability for individuals to transfer their data from one entity to another. And this will create a new enormous amount of activity online that will empower Canadians and create opportunities in many areas, including, as I mentioned, in the financial sector, in open banking, for example.
Comments? The Honourable Member for Haldimand, Norfolk.
Well, thank you, Madam Speaker. You know, it's great to talk about data portability and privacy, but it doesn't matter if Canadians don't have access. And in the Connect to Innovate program, the government spent a lot of money, except they didn't spend a single penny in southwestern Ontario, connecting businesses and Canadians and residences with the internet to give them proper service. This area represents 20% of Canada's economic output. In my own area of Norfolk County, over 30% are still underserved. There's no indication of a carve-out in the new program for funding, but there's also parts built in for financing that would only benefit the big players. If the minister is serious about his commitment to small business, will the new program be modified to support small ISP providers and to provide service to southwestern Ontario so that everyone can enjoy the new freedoms and protections about which he's speaking today?
Honourable Minister.
Madam Speaker, I'd like to thank my honourable colleague for her very thoughtful question and for her advocacy on the issue around connectivity. She knows personally very well, as a minister that served in the previous Harper government, the importance of broadband connectivity. And if you look at the digital charter, the first principle talks about access. It is an important principle that we put forward in the digital charter, and it highlights the commitment that we recently made with regards to build on the work on the Connect to Innovate program through the Universal Broadband Fund, as well as looking at low Earth orbit satellite technologies to provide that high-speed internet connectivity for rural and remote communities. And I can tell you right now, from our perspective, it's all about more competition, which will provide more choice to internet service providers, particularly the smaller ones, which will enable prices to go down, and which will provide options to many Canadians, including those living in Southwest Ontario.
Le temps pour une brève question. L'honorable député.
Time for one last brief question. The Honourable Member for Thérèse de Blainville. Thank you, Madam Speaker. This bill doesn't have us consider our own data. Now, we saw what happened with the Revenue Canada, with the agency, how easy it was to have one's identity stolen in a number of ways. The tools are outdated with respect to identity and security. Why does this bill not include rigorous standards within government agencies and ministries?
Madame la Présidente.
Thank you, Madam Speaker. I would like to thank my colleague for her question. I understand the situation surrounding the security of Canadians, and I hope that we can work together to find solutions for all Canadians. Thank you.
Resuming debate, the honourable member for Sturgeon River Parkland.
Well, thank you, Madam Speaker, and I heard some applause back there, so I'll take that. Today I'm rising on Bill C-11, adulation, thank you, an act to implement a digital charter for government. And this is an auspicious moment for Canada because we are well underway into the digital age, and the need for clarity and concrete action to protect Canadians' privacy is a paramount need. And while it is critically important, we also need to remember the need to protect small and medium-sized enterprises and to ensure that Canada can remain globally competitive as a jurisdiction for technology, data, and innovation. And I am concerned by some of the trends that we have seen over these past few years with Canada falling behind our global competitors. And I'm concerned that some parts of this legislation could put us behind. I'm also concerned that we are falling behind when it comes to security. It's all great to talk about protecting Canadians' privacy and putting in consent-based rules, but in an age of quantum decryption and computers that can break a 120-bit encryption, if our security can't be protected, then all the consent laws in the world and all the privacy protections in the world aren't going to mean much. So I want to break down this bill into terms. They talk about plain language in the bill, and so I'm going to try to talk in as plain of language as we can when dealing with a matter of this technical nature. And I want to talk about some of the challenges, and I'll grant the government some of the opportunities that we foresee with this legislation. And I want to start also by recognizing and thanking the work in the previous Parliament of the Ethics and Privacy Committee under the able chairmanship of my colleague from Peace River, Rocky Mountains, and under his chairmanship. And many of the recommendations that we've seen in this legislation comes from their committee's report. And so I think that shows Canadians that committees do really matter in this House and that they can make a positive impact. So as I said, one of my chief concerns with this bill is the impact on small and medium-sized enterprises. It's been said for a number of years now that data is the new oil. And for many emerging enterprises, access to data and the ability to use this data will be the determining factor in whether they're successful or not. Now, I don't need to say, but I will, that small and medium-sized enterprises are the lifeblood of our communities, and increasingly we're seeing how vulnerable they are, especially during this pandemic. Now, we have to consider the context of this legislation within the economy and the economic structures that this Liberal government has created over the past 5 years. We've seen an unrelenting attack on small and medium-sized enterprises, starting with hikes to the Canada Pension Plan premiums, hikes that will be continuing even this January in the midst of a pandemic when companies are closing their doors and laying off workers. The government's looking at increasing costs even further for employers and employees. It's just not acceptable. And now the Liberals in the past accused business people of being tax cheats when they utilized exemptions under the tax code. And they decided to take one step further by hiking taxes and removing these exemptions for many family-owned businesses, including a lot of businesses and farm families in my riding. Now, with this legislation, they're adding on yet another layer of red tape that will force many onerous requirements on small businesses. And with that being said, I recognize that, you know, many of these requirements will be very helpful when we're talking about large businesses. And they certainly do have the resources to maintain these privacy requirements. I found it interesting that the minister was talking about, well, the right to delete yourself. Well, I mean, on many social media platforms, that's been the case for a number of years. So it feels like the government is, you know, trying to catch up on this legislation from what businesses are already largely doing. But we see that small enterprises are increasingly reliant on technology and data. And when we look through this legislation, there's a number of new requirements. There's a certification requirement. There's a requirement for them to designate somebody in their business to be the privacy watchdog. They have to maintain databases. They have to be ready to respond to customer requests or investigations. And when we're talking about some of these very small businesses, where it could just be 2 or 3 staff or even maybe a sole proprietor, to add this new layer of red tape on that is really going to create a lot of new challenges for small businesses. And ironically, it will actually benefit the big businesses, because when small businesses have more red tape, they might just decide to no longer go in business. And so we'll see even more consolidation amongst the big players, the Amazons and the Walmarts and companies that you know, are large collectors of personal data. And we'll see, you know, our thriving, innovative startup economy start to get strangled under some of this legislation. So I certainly hope that when the government is considering amendments at committee, that they really you know, consult with small businesses. I encourage them to consult with the CFIB to really look at the challenges that these small businesses are going to face and try to come up with some sort of threshold to ensure that they are not unduly burdened. Now, I appreciate that this bill is largely targeted at major corporations and tech giants who use massive amounts of our personal data for everyday business. And we know that these companies have the capacity to do better in protecting our privacy. And I hope that this legislation can spur further commitments to protecting Canadians' privacy. But as I said, it does bring me to the concern that these large corporations largely have already implemented a lot of these things that the government's talking about. They have the human resources and the legal departments and the endless ability to tap debt markets and bond markets and stock markets to finance these changes. And frankly, small businesses do not. And in one of the questions that I asked to the minister, which the minister really didn't answer, when we're talking about data portability and the impact on small and medium-sized enterprises, you know, the minister couches it in terms of you as the consumer have the right to ask for your data to be moved from one organization to another. And it seems like a really great thing, but I mean, I can't really think of too many situations where a regular Canadian would be the person who is initiating that conversation. But I can see where a bank, for example, when dealing with the insurance arm of the bank, so many of the large Canadian banks also have insurance companies, there's been a fence put around these companies to ensure that, you know, they don't become too big and anti-competitive. So you currently can't share information between insurance companies and banks from the same company. But now through this legislation, the insurance company just needs to provide a plain language document saying, would you consent, would you want your information to be shared with our banking arm? And we can see how quickly, with all that massive amount of data that insurance companies and banks have on Canadians, we're going to see them, you know, possibly use this as a predatory practice to increase and consolidate and to suck customers away from small and medium-sized insurance companies. And when I'm driving through my riding of Sturgeon River Parkland, I'm proud to see, you know, about a dozen, you know, small and medium-sized insurance businesses that are doing auto insurance, home insurance, life insurance. I mean, there's tens of thousands of Canadians employed in this important industry, and they're not all working for the big banks. And I really am concerned that this legislation could be making our marketplace much less competitive. And so I would hope that the government considers that impact as well. So my next point is when it comes to enforcement, I'm really skeptical about the government's ability to deliver for Canadians. We see, in spam legislation and other legislation that, there's a lot of, action, or there's a lot of words that are not being put into action, and consequences that we're not seeing followed through on. So similarly, this legislation, it packs a lot of firepower. It's talking about threatening $10 million in fines, or up to 3% of global revenues. And this is certainly, it's the toughest in the G7, as the government has said. But I just wonder, what powers does the government really have to compel payment? When we're talking about the potential serial abusers of our private data, we're talking about massive multinational corporations with billions in revenues. And I wonder if we can anticipate similar challenges to those faced by France when they attempted to collect taxes on United States digital giants. These included, the challenges included a challenge at the World Trade Organization, retaliatory tariffs on French products, and I wonder if the Liberals have given any thought to the potential consequences of trying to collect large fines from these companies. Does the government anticipate that our trade competitors are going to let these challenges go unanswered when we try to collect? Have they considered the consequences that this could have on the Canadian economy, and are they ready to be open about this very real threat? Now, I'm not saying that this isn't something that they shouldn't pursue, but I am saying that we need to know what the potential consequences are before moving too quickly on this. Now, Canadian innovators are at the forefront of technological advancement, and I think it's something we can all be proud of. However, a concern that has also been brought to my attention is the protection of proprietary algorithms by startup tech companies that rely on data. Now, some of the provisions in this bill enforce algorithmic transparency, which it sounds great for consumers, but I also see that it could be used by business competitors to expose sensitive, confidential, and proprietary information. And has the government considered the consequence of what these actions will do to our startup companies who want to keep their algorithms proprietary, they want to keep them confidential? Maybe they're in a situation where they're looking for a buyout at a later date, but they just need to build up to the point where they can really get the value that they believe their company is worth. But with this algorithmic transparency, could it be used by their competitors to investigate, the use of their algorithms and use that to possibly steal things that are patent pending, or use it as leverage in a negotiation for a buyout? So I want to see that there are more stringent protections for our nascent technological sector to protect their algorithms from being exposed. The next thing, this bill talked about, and the minister sort of alluded to it, and I think we need to drill down and explore the idea of an exemption for socially beneficial purposes. Now, the minister provided some, examples: government, healthcare agencies, education, and I don't think many Canadians could really object to these organizations being exempted. But I'm also, there was one particular point that said, an organization that exists to promote environmental protection. And we believe in strong environmental protection, but are we possibly talking about, environmental charities that may have had, a political arm that had an agenda in an election? Are they going to be exempted to use Canadians' data in any way they see fit? And what potential consequences could this have on keeping our elections free from foreign influence, or ensuring transparency in political communications? So I would really like to get a much clearer idea of what the government really means when they're talking about socially beneficial purposes, because we're living in an age where, you know, as the member for Timmins James Bay said, there's data wars going on, and you know, if organizations are misappropriating this data and using it to influence our elections and our democratic process, if they're being provided an exemption, I think we really need to explore that. The next thing I wanted to talk about was the 10 pillars of the digital charter, which the government has brought forward. Now, we know a charter, as any statement of values, is really only as good as the resources and the enforcement that's put behind it. So I want to highlight a few of these pillars and address some concerns that I have. So pillar 1 is talking about universal access. All Canadians will have equal opportunity to participate in the digital world and the necessary tools to do so, including access, connectivity, literacy, and skills. Well, the fact is, as my colleague from Haldeman, Norfolk was saying, too many Canadians, the fourth coast, as some would say, even in relatively urban areas, we are far from accessing high-speed and reliable broadband services. And for years, successive governments, have pocketed billions and billions of dollars from spectrum auctions, and they have been announcing and re-announcing, and in some cases re-announcing a re-announcement on enhanced rural broadband. And these Liberals have promised the Universal Broadband Fund as their solution. They even claimed that they topped it up by another $750 million a few weeks ago. But communities in my riding who recently applied for the Universal Broadband Fund were told that they didn't qualify. Now, I come from a fairly rural riding, and they were basically told, well, according to our data, the internet, it says your internet is fast enough. Well, that's not acceptable. Try explaining that to a farming family in Sturgeon or Parkland.
Draw me closer to your side. Take your page out of my story. I don't mind. No. Move. Keep it steady, never falter.